Get fit and stay that way with the help and encouragement of Bellingham Athletic Club, Whatcom County's most comprehensive fitness center. Innovative classes, state-of-the-art equipment, fitness professionals to help you reach your goals, and 2 convenient locations. Bellingham Athletic Club, more than just a gym, downtown and Cordata.
This is Bonner and Brooks on KGMI News Talk 790.
No Bonner, no Brooks. It's Ellison Cartier. I think we'd have to get a better name. I'm Tracy Ellis, news director here at KGMI. Sitting in for Brett, I guess, and then Jackie, who you all know, usually does the news on this program, sitting in for Patty Brooks.
Yeah, they both have that bad bug that's been going around, so we hope they get better.
Absolutely, absolutely. And we're going to talk about the Second Amendment today. I'm surprised the phones aren't already ringing, because obviously it's a very emotional topic for a lot of people. A lot of people are passionate about it. And the reason we're talking about it is the Supreme Court is hearing arguments on the constitutionality of the District of Columbia's ban on handguns. Yeah, Washington, D.C. about, I think it was over 30 years ago, about 31 years ago, banned handguns in the city. The city is asking the justices to preserve its ban. Case centers on the meaning of the Second Amendment's right to keep and bear arms. And we're joined by Jeff Teichert. He's an attorney here in Bellingham. Good morning, Mr. Teichert.
Good morning.
Appreciate you being on with us. And it's interesting to me, one of the things that surprised me about this is that the Supreme Court really hasn't ever taken a stand on this. They haven't really dealt with this in quite a long time. I mean, it's been years, right?
Right. There was the Miller case, 70 years ago or something, that had sort of a tangential impact on it, but didn't directly take on the issue that at least many are hoping the court will take on this time.
The reason Mr. Teichert is with us today, well, first off, he's just a good source for information on this, but he also is participating in the case. The Citizens Committee for the Right to Keep and Bear Arms has filed what's called an amicus brief, and it was written by our own Mr. Teichert. So he's on to talk about that today. And I guess first off, for all of us who aren't lawyers, what is an amicus brief?
Well, an amicus curiae brief is a friend of the court brief. And what that means in practical terms is, a case makes its way through the system and makes it all the way up to the Supreme Court. And there are various parties that will have things that they would like to say about it when it gets to that stage. You can file amicus briefs at lower levels, but obviously when it gets to the Supreme Court, you will get a plethora of them because anytime the Supreme Court speaks on an issue, it's going to be significant.
Right, something that could change really the entire law, basically. I mean, it's based on some of their decisions that could change the way we do things in this country.
Right. So an amicus curiae brief would be if a party wants to say something that they don't think is going to be covered in the main briefs of the parties, they will sponsor an amicus curiae brief to advise the court on their particular perspective or issues that they want to have placed before the court.
Mm-hmm. Okay, that makes sense. And the Citizens Committee for the Right to Keep and Bear Arms, they're located here in Washington, right? Based here?
Correct. I represented them along with the Evergreen Freedom Foundation located down in Olympia and a number of university professors that wanted to say something about this.
Yeah, and I was going to ask, why you? Why did they pick you? Besides being a very talented lawyer, I'm sure.
Well, it's a long story, but to make it as short as I can, I received my Master of Laws degree at George Washington University. And my master's thesis advisor is a PhD in history as well as a Juris Doctorate degree. He teaches in both the law and history departments. His name is Robert Cottrell, and he's one of the leading Second Amendment scholars in our country. And so I had the privilege to study under and work with him. And when this issue came up, before the Supreme Court, I was interested in doing something if I could, and I contacted the attorneys for the main party, and Professor Cottrell was in consultation with them, and so when my name came up in meetings about who they might organize various amicus briefs to be filed with, my name came up, and Professor Cottrell said, well, I think he would do a great job, and so that's kind of how I ended up.
Wow. I mean, it's amazing, basically participating in in a case at the Supreme Court, I mean, that's as big as it gets, right? That's your Super Bowl, I would imagine, or something close to it.
Right. Particularly in an important constitutional case of first impression like this, it's kind of every lawyer's dream in some ways.
Okay, I know. I'm sure the brief is anything but brief, but can you just kind of sum up what it says, what your position, or I guess the Citizens Committee for the Right to Keep and Bear Arms and the Evergreen Freedom Foundation, their position is, and how you kind of spelled that out in this brief?
Well, the concept of the brief was premised on the idea, which is well known in appellate advocacy, that you don't want to spend too much time on your opponent's arguments. You want to put your own arguments in front of the court. So my brief attempts to take directly on the opponent's arguments, some of their leading amicus curiae briefs as well as the main brief, and look at some of the myths that have commonly been perpetuated about the Second Amendment. So it covers a wide variety of topics and tries to do so briefly, and they range from historical errors to factual and statistical problems that are often advanced to defeat the individual right to bear arms. So
it's interesting. Obviously, you've become an expert in this, in a sense, right? I mean, you'd be described as somebody who probably knows more about the Second Amendment than your average lawyer or even a lot of historians.
Right, and my Master of Laws was in British and early American legal history, and so I hadn't applied that specifically in writing about the Second Amendment before, but it was interesting to take that sort of general knowledge and then look into some of the sources about this topic. Well,
and it's great to have you here because obviously this is top of mind. It's happening right now, and we want you folks out there to be able to give us a call to talk about it and talk with someone who is an expert on the Second Amendment, Jeffrey Teichert. He's our guest. This is Bonner and Brooks. Tracy Ellis sitting in for Brett Bonner, Jacqueline Cartier for Patty Brooks. We'll be right back.
Get fit and stay that way with the help and encouragement of Bellingham Athletic Club, Whatcom County's most comprehensive fitness center. Innovative classes, state-of-the-art equipment, fitness professionals to help you reach your goals, and 2 convenient locations. Bellingham Athletic Club, more than just a gym, downtown and Cordata.
Welcome back to the Bonner and Brooks program. Tracy Ellis in for Brett Bonner and Jacqueline Cartier in for Patty Brooks. They're not feeling well today.
Yes, we hope they do feel better, though.
Absolutely, and we're talking with Jeffrey Teichert. Jeffrey Teichert is an attorney here in Bellingham, and he wrote an amicus brief in this case. What is the actual, it's funny, all these news stories, I don't think I've seen the actual name. Oh, here it is, District of Columbia versus Heller. Basically, it centers on the meaning of the Second Amendment's right to keep and bear arms.
Yes.
And what's interesting about that, because I could see why it's difficult to interpret exactly what the founders were trying to say with that, because it almost gives two messages. One, it talks about militias.
Yes.
And then it also talks about the right to bear arms. And I think where the confusion is and what the argument is here is, hey, it's just intended. Some people think, hey, it's just intended to allow militias to operate within our state, basically to protect us. It's not a right like the right of free speech or the freedom of the press, which is important to us. I would imagine that you argue that it is a right, and they did mean it to be that.
Right, and I mean I understand the confusion, but let's look at it textually to begin with. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, there's obviously a lot of history that goes with both of those clauses, but if you look at the Bill of Rights in total and look at how the words the state and the people are understood in the context of various amendments, when the founders said the people, that had a very specific meaning. And I think where the militia clause comes into that amendment, we need to look at at sort of what the context of that was in the time, number one, there was a great fear of standing armies in that time. People thought that they were dangerous to freedom,
Right.
that the army could become sort of a special interest group, if you will, a faction with its own interests that weren't necessarily in harmony with the interests of society. They would rather have a citizen army.
And we've seen that in other countries. I mean, even to this day, we see armies that kind of go out there on their own and have a coup and take over a country.
Exactly. And so you had, for instance, John Adams calling for a militia, and this is a quote, a militia law requiring all men or with very few exceptions. Or Thomas Jefferson saying in his notes on Virginia, every able-bodied freeman between the ages of 16 and 50 is enrolled in the militia. Or Joel Barlow, who was a prominent Revolutionary-era pamphleteer, wrote, every citizen is a soldier and every soldier will be a citizen. The idea that we wanted a militia, and you see this all over in the early writings,
Mm-hmm.
composed of the body of the people. The
Right.
body of the people was the idea. So when you talk about the right of the people to keep and bear arms, really the idea was that the militia was a militia of the whole, a militia of everyone.
That's interesting. I don't think I've ever heard it explained that way. That's the whole idea of the militia. So if that's the basis for it, then you're right. I mean, the people who say, yeah, it is a right, and it was very important to the founders because obviously you can't have a militia if they're not armed.
Right.
But Jeffrey, what about people who say, well, this is just antiquated? I mean, that was the case then, and that now times are different. I mean, I'm sure you were mentioning earlier that in your brief you have to deal with a lot of what you perceive as myths and misconceptions that people have with the Second Amendment. What's your response to that? That this is old school. I mean, this isn't something that should apply today.
Well, if it doesn't apply today, we ought to repeal it. But I would argue that it does and that it should. And here's the reason. We can get into statistics later on. I think that there are some statistical myths about the effectiveness of gun control. But from a more core philosophical and political idea, the power in the country is where the weapons are. Ultimately, that's where the rubber hits the road. To quote Chairman Mao in China, he said that political power grows out the barrel of a gun, and that's true. And so if we want to maintain power in the people, that's where the arms have to be. I agree with Jacqueline that currently the idea that the people need to rise up and overthrow their government seems remote, and even the Declaration of Independence said that that kind of thing shouldn't be done for light or transient causes. But in terms of it being antiquated, the need for the people to replace their government, keep in mind that in the 20th century, somewhere between 60 million and 100 million people, depending on what statistics you use, were murdered by their own governments. And typically those were in countries where the right of the people to keep and bear arms was not able to be exercised.
I guess part of it is, where do you draw the line? I mean, if we wanted our citizenry to have the same weapons as our army, for example, I mean, that's pretty crazy. You're not going to have a battleship sitting in your pool in the backyard or a tank, on the front yard. I mean, so I think what Jack is saying, these are different times.
Right, and I think that we have to consider it as we would have in those times as well. There have been some limitations, for example, placed on the right by certain state courts, a couple of which are cited in my brief. There was one, for example, that said the average citizen, for purposes of protecting their home, participating in a state militia, or self-defense purposes, doesn't need a machine gun, for example, or a sawed-off shotgun. Those are more typically arms that are used just by criminals.
Mm-hmm, sure.
But the quibble with the D.C. law is that the handgun is really the weapon of choice for homeowners to defend their home.
Okay. 676 KGMI is the phone number, and we will be taking your calls when we come back. We're going to do a quick news break. Jackie will have the news for you, and we'll be back with attorney Jeffrey B. Teichert talking about the Second Amendment, and specifically about this case going on in front of the Supreme Court right now, Washington, D.C., and their ban on handguns is being challenged. And it's a very important case, and I'm sure you'll hear a lot about it in the news, and we're talking about it right here on KGMI's Bonner and Brooks program.
Get fit and stay that way with the help and encouragement of Bellingham Athletic Club, Whatcom County's most comprehensive fitness center. Innovative classes, state-of-the-art equipment, fitness professionals to help you reach your goals, and 2 convenient locations. Bellingham Athletic Club, more than just a gym, downtown and Cordata.
Welcome back to the Bonner and Brooks program. Tracy Ellis in for Brett Bonner, Jacqueline Cartier in for Patty Brooks, and here we are. We're doing a show about the Second Amendment today. And how great is it to have Jeffrey Teichert in with us? He's a Bellingham attorney, and he's not just here as a quasi-expert. He's an expert, and he's actually participating in this case in front of the Supreme Court and having to do with the District of Columbia's ban on handguns, and the city is asking the justices to preserve that ban. Case centers on the meaning of the Second Amendment's right to keep and bear arms, and obviously a very important case. And Mr. Teichert, once again, thank you for being with us. And you said something interesting earlier, and I've always felt this way too, that if Jackie said, well, isn't it antiquated? Okay, well, if it is, then we should repeal it. And we have the ability to change the Constitution. Actually, the Founding Fathers thought that was very important, the ability to do that, because times do change, and they understood that. So I guess that's the question. Why not repeal it if it's out of date?
Yes, and before the break we talked. I tried to make the argument that if it is antiquated, we should repeal it. But in my opinion, it is not antiquated. Because we don't draft a constitution for the moment, we draft it for the ages, and it is meant to preserve liberty in the long term. And I think that's a critical thing to think about. Right now, it seems remote that people in the United States would ever have to do what we did in 1776, and to somehow overthrow our government. But times change. And if times ever change and things start to look like we're going to be ruled by a dictator or have an oppressive government, the sovereignty of the people would indicate that they have a right to alter or abolish their government, as indicated in the Declaration of Independence, and that is my argument. That
right.
Even in the 20th century, 60 to 100 million people were murdered by their own governments.
Right. 676 KGMI, the phone number. And Bob, hi, welcome to the show.
Hey, I'm glad to hear from Jeffrey Teichert on this situation, because he's dead on about this Second Amendment. And I often think, that times change, and they do, but my great-grandfather migrated from Italy in 1792 and fought in the war. He left his regiment from the British and switched over to the American side, and he fought on the side of the Americans in the War of 1812, and I'm certainly glad he did that, or otherwise I might not have ever been born in this great land of ours, choice above all others.
That's a great point, and a great story, and I think that it's interesting. If you talk about from a historical perspective, and there's so much of what we're talking about is based on in history, and I think that Bob obviously has a personal understanding of that. Bob, is that how you feel? Is that why you're so passionate about it?
Oh, well, yes, that's partially, but I believe in the right to bear arms because our family, and of course we live in a little bit of a rural area, and my family has had arms ever since they've been born, and we've always been taught how to handle them, how they can kill people or injure people, and we always have them safely taken care of and taught to people, because you have to remember that guns don't kill people, people kill people. Well, and I don't know how you're ever going to control all of that, but banning them and taking them away from the people is not the answer.
Well, Bob, thank you for the call. I appreciate it. And one thing that he hits on there is it's interesting because in that I forget what's the Bowling for Columbine. He talks about, obviously he seems to be opposed to the Second Amendment. But one thing that I thought was interesting, that when they went to Canada, Canada has as many guns, and just a small per capita, just a small fraction of the number of gun deaths. And I thought that was interesting. So I guess that's the point Bob was making.
It could be, and I think if you look at Canada's gun laws, that's one example cited by the District of Columbia. But by any stretch, the District of Columbia's handgun ban is far more restrictive than anything in Canada.
Okay. Gene, welcome to the program.
Good morning. Good morning. Thank you for bringing up this topic. There's something that I'm wondering about. It's a question. When this was written at the time of these militia, these people were, did the individual citizens, the people that joined the militia or whatever, did they sometimes or ever or often use their own weapons, or was it always furnished by the government?
In a militia, it was almost always their own weapons.
Yeah. Okay. Well, I think that's a big point. If you're called out for a militia, you need your own weapons, and I think this was considered at the time.
Yeah, that's an interesting point that he makes, because back then they didn't have the money to, provide arms to everyone fighting in a militia. I mean, in the point you made earlier, the founding fathers talked about this idea of everybody, you're born into the militia. If you're a citizen, you're a member of the militia.
Right. And there was a twofold reason for that. One, as I mentioned before, they believed that standing armies were dangerous to liberty, and they wanted a very small standing army and a larger citizen militia to defend the country, because they thought it would be more broadly representative of the people. And then the second reason was, of course, if the standing army or the government got out of control, the people wanted to have the power to take care of that. One of the points cited by the District of Columbia is they selectively cite certain definitions from Webster's dictionary, definitions of arms that indicate a military connotation, which is obviously one of the applications of that term. I would offer an alternative one from that particular definition. In law, arms are anything which a man takes in his hand in anger to strike or assault another. And Noah Webster, the author of the dictionary, many people don't know this, but was one of the members of the founding generation, and during the Constitution ratification debates, he said, "Before a standing army can rule, the people must be disarmed, as they are in almost every kingdom in Europe. The supreme power in America cannot enforce unjust laws by the sword, because the body of the people are armed and constitute a force superior to any band of regular troops that can be on any pretense raised in the United States." So in that era, it was very important to the people to have the power in the people, and not just in official government-sanctioned organizations.
We have to take a quick break. We'll be taking more of your calls when we come back. 676 KGMI, the phone number. Bonner and Brooks, Tracy Ellis, and Jacqueline Cartier in for the ailing Patty Brooks and Brett Bonner today.
Get fit and stay that way with the help and encouragement of Bellingham Athletic Club, Whatcom County's most comprehensive fitness center. Innovative classes, state-of-the-art equipment, fitness professionals to help you reach your goals, and 2 convenient locations. Bellingham Athletic Club, more than just a gym, downtown and Cordata.
Welcome back to Bonner and Brooks. Tracy Ellis in for Brett Bonner, along with Jacqueline Cartier in for Patty Brooks. They are under the weather, and we'll be back hopefully tomorrow. That's what we're kind of hoping for, right?
Yeah, this feverish thing is kind of going around, I guess, and they both got caught up in it, unfortunately.
The United States Supreme Court is hearing arguments today on the constitutionality of the District of Columbia's ban on handguns, and we have a lawyer who filed an amicus brief in that case from right here in Bellingham, Jeffrey B. Teichert. And let's go back to the phones. We have Phil with us now. Hi, Phil.
Hi. It seems to me that there's more at stake here than just the ban of handguns. in order to, as I understand it, in order to change the Constitution, you have to call a constitutional convention, and then everything has to be ratified by the states. Now, if they call a constitutional convention, that opens the floodgates for other things like same-sex marriage, a whole bunch of things. So, there's more at stake here than just banning handguns.
Well,
and
Phil,
I happen to believe in the right to bear arms.
Okay, and Phil, we aren't talking, really, there isn't that much at stake. I think what we're talking about today and what
That's your opinion.
No, I'm just saying we aren't talking about changing the Constitution here. The Supreme Court is listening to a legal case. It's, you're right. I mean, changing the Constitution is quite the process, but, I don't think that this case has those types of implications. Now, Jeffrey, maybe I'm wrong.
And when I threw out the idea that if we thought this amendment was antiquated, we could repeal it, I wasn't suggesting that we do that. I was merely saying that the idea that it's antiquated, so the Supreme Court ought to unilaterally write it out of the Constitution. If we really feel that way, we the people ought to amend the Constitution and get rid of it instead of having the court do that by judicial fiat. But I agree with Phil, though. I believe in the right to keep and bear arms, and I wouldn't be for an amendment like that.
Right. And Phil, I think you make a good point about changing the Constitution, because there's a reason it is so difficult to do it, and it takes so long, and it's, such a,
Well, I believe in what our forefathers thought about, too, and it's a timeless document,
Oh, absolutely. Thanks so much for the call. I appreciate it. Elizabeth, you're on the line with us now. Hi.
This is very interesting. We have a lot of family records, and one of my ancestors in colonial Connecticut, this is before the Revolutionary War, was fined 5 pence for not keeping his rifle clean. That was where the important thing then. Everybody had to have a rifle, had to have it clean. And if you don't keep it clean, you're going to get fined 5 pence, apparently.
Yeah, do you think our perception of guns have changed, Mr. Teichert? Do you think maybe that's part of what's leading to, some of these bans, and just in our history now, the way we view arms has changed a little bit from how it used to be?
Well, I think we have, as many point out, gone from a more rural to a more urban society, and particularly in places like the District of Columbia, people are concerned about the use of a weapon in crimes. But there are good statistics that show, for example, that they're equally effective in defense against crimes. A good example is that there are statistics by the Department of Justice, and these are cited in my brief, that demonstrate that in a case where a person's defending themselves against an intruder with a weapon, 1 in 5 will be injured if they themselves are armed. If they're defending themselves with a different weapon other than a firearm, or no weapon at all, half are injured. One of the persistent myths is, you're more likely to be injured by your own gun than you are by an intruder. Your self-defense risk is actually greater if you have a gun.
And we do hear that a lot. Hey, we're late on a break. We have to take it real quick. We'll be right back here on the Bonner and Brooks program.
Get fit and stay that way with the help and encouragement of Bellingham Athletic Club, Whatcom County's most comprehensive fitness center. Innovative classes, state-of-the-art equipment, fitness professionals to help you reach your goals, and 2 convenient locations. Bellingham Athletic Club, more than just a gym, downtown and Cordata.
Welcome back to Bonner and Brooks. Trace Ellis in for Brett Bonner and Jacqueline Cartier in for Patty Brooks. They are both ill, and we are talking with Jeffrey Teichert, a Bellingham attorney who filed an amicus brief in this case, the Supreme Court case dealing with the District of Columbia's ban on handguns. And briefly, we only have about 40 seconds left, Mr. Teichert. What are some of the things the Supreme Court is going to consider in making their decision?
Well, I think that the core issue is going to be whether or not the Constitution protects an individual's right to keep and bear arms. And I think fundamentally that's what people are hoping that they're going to take up.
It's pretty basic then, It really boils down to that.
It boils down to that, and then, of course, the extension of that, whether that is violated by eliminating a class of weapons like handguns.
Well, thanks so much for your time, sir. I really appreciate you joining us today.
I enjoyed it. Thank you.
And I appreciate everybody being so kind to us filling in here. And again, we're hoping they'll be back tomorrow. But for now, I'm Tracy Ellis with Jacqueline Cartier saying goodbye from the Bonner and Brooks program.